Hi, everyone. Nice to talk to you today. For those of you who've not spent time with me before, my name is Heidi Seaton. I'm the VP of Legal and Compliance here at Orange Tree. I do always spend a little time on this slide, just a reminder. I'm not your legal counsel to be thinking about things you may not have heard about in background screening. And we just urge you to be talking to your own legal counsel if you have questions about your background screening program. That said, we do have a lot to talk about, actually. Sometimes there's as few as 3 agenda items and lots to talk about. This session, this quarter, for whatever reason, we've got sort of broad but not too deep set of agenda items to look at. So we'll start to talk about some state court access activity, things that are going on there, mostly updates there, some ban the box activity. We'll start talking about clean slate. We haven't spent much time on that in past sessions, but we're hearing more of these sorts of state statutes being enacted. So we'll spend some time bringing you up to speed on what to be looking for and hearing there. We've had a little bit of activity on state drug testing, both legislative and some litigation to talk about there. Updates on E-Verify. We had an update last quarter on some of the COVID related rules that went into place for the I-9 form. Now we have an update on the E-Verify process. A few interesting cases, so some litigation that we're keeping an eye on that we wanted to talk to employers about, some news in the Fair Credit Reporting Act, especially interpretive guidance. We're seeing, I feel like a lot, comparatively, a lot of FCRA interpretive guidance. So we'll go through a few of those items and then talk about data privacy and what we're seeing both state, from a state level and at the federal level. So launching off with court access, you may remember this is not new, but we do have a little bit of movement in California. So back in May of last year, we saw the Court of Appeals provide a ruling. That was the all or none of us case. There was a court rule in California that said that courts would provide a public index. And then with that Court of Appeals ruling in 2021, the rule was interpreted to say that dates of birth and driver's license numbers could not be used to identify an individual when searching a court's electronic index. So you guys are living this with us, has resulted in really significant delays for employers where researchers have to submit possible records or name match records to clerks for clerks to confirm identifiers, manual process in many cases, time-consuming process in many cases, and the Court of Appeals did not back off on that ruling, despite a fair amount of lobbying and concern from employers that this new rule was creating delays in the hiring process and potentially creating liability for employers if they weren't able to confirm records. But we are seeing here earlier this quarter, a new bill passed in California, a new bill introduced in California. It did get through the Senate in May, and it's been taken up by the Assembly. It recently got referred to appropriations. I'm not sure if that's good news or bad news, but a little bit of activity happening there. It's definitely the right direction. If you look at the legislation itself, it's literally, I shouldn't say literally, but I believe it's a single sentence being added to the rules that would require date of birth or driver's license to be searchable on that public index. So hopefully that will continue to go in a direction that's positive for employers. We'll keep an eye out on that one. In the meantime, we are experiencing some delays there. And we just keep working through them. If you have questions about that, or if you want to talk to anyone on our client care team about delays in California due to this, we're happy to have that discussion with you and give you a little bit more information about anything specific going on. Michigan, another update. So again, we talked about this last quarter in our last session, but It's worth just reviewing again. There, the Supreme Court in Michigan had also adopted a court rule and started to redact personal identifiers from public records that really limited employers' ability, again, to confirm records actually belong to the individual about who they relate. And they did earlier, at the end of last year, adopt a negotiated court rule on redaction. It addressed concerns with that original proposed rule. And they did move the effective date that was supposed to be effective in January. It got moved to April, but they did actually implement it in April. It's been going fairly well. For the most part, we're finding court clerks there are participating. They've stopped redacting. They're providing additional identifiers when we need them. And so a case there in Michigan where things went badly for a while, and now we're seeing that turn around a little bit. So much better things happening in Michigan, and still a little bit slow. And we're still seeing, some courts that are still working on getting some of those identifiers back that they may have redacted before the rule was actually officially implemented. But movement, good direction of movement in Michigan for employers. So in Ban the Box news, so again, Ban the Box is the effort to remove the question about criminal history from the employment application. And we saw this Ban the Box movement sort of happening in the box legislation, sometimes effective for private or public employers, sometimes also for private employers. And then last year, well, actually in 2019, we saw the federal passage of the Fair Chance Act. And the effective date of that was late in 2021. So that, again, only affected federal government employees and some federal contractor employees. And so doesn't affect, it's not a national standard for all employers. It's really only federal employees and federal government contractors. But what did also come out of that, so what the Ban the Box aspect of that Fair Chance Act was that certain federal government and federal contractor employees may not require an applicant to disclose their criminal background on a job application or during an interview or prior to the conditional job offer. And the FCRA called for the Office of Personnel Management to create regulation, further regulation for employers and federal contractors. So that's what we're starting to see here. The OPM came out with proposed regulations. This first set of regulations is only for federal government employees. So it doesn't actually yet apply to federal contractor employers, but it is expected that this regulation will be used as a footprint or as a template for what's likely to happen for federal contractors. So of interest, so it does identify the positions for which that prohibition against asking criminal history information does not apply. So federal contractors especially will want to be keeping an eye on that set of regulation. So we almost every time talk about Ban the Box, and this time I'm also introducing this idea of clean slate law. They come together very often, or you'll get one and then the other. And the idea of a clean slate law is most states, I'm sure you're aware, have a mechanism for criminal records to be expunged or sealed through some petition process. So there's a conviction, maybe there's some time served, maybe there's some sort of probation or some other activity that the individual is required to fulfill. Once they do, some cases are then eligible to be sealed or expunged, and that's usually a court order process, right? You have to petition the court to consider sealing or expunging that record. Well, what we're seeing with clean slate laws is a more automatic process. So they remove that need to navigate the expungement or the sealing process and automatically trigger certain records to be eligible or to automatically be sealed or expunged, usually based on the type of the offense, based on some prescribed time period from the last court action, or when there was a release from parole or something like that, or satisfaction of some other prerequisite, some sentencing guideline or some diversion program, for instance. So we did see in Colorado that they signed one on June 1st. Or the governor signed that law into law on June 1st, and it does cover, so civil infractions or petty offenses are eligible to be automatically sealed 4 years from the final disposition. Misdemeanors eligible to be automatically sealed 7 years from the final disposition or release, whichever is later. Felonies eligible to be sealed 10 years from the final disposition or release, whichever is later. And again, they did put some guardrails in there. Violent crimes, murder, assault, sexual assault, robbery are not eligible for automatic sealing or expungement. And then they expect to have this automated part of this happening in 2024. So what does this mean for an employer or for a CRA? It's sort of it is a set of records that are no longer available to the employer, or that will no longer be available to the employer. So it really does limit the employer's ability to know everything. But practically speaking, basically, your CRA, your public record researcher, your court runner, the records won't be findable anymore on the court terminals. So essentially, employers just won't know about criminal records; they'll be gone. This statute would say they can't use them anyway, so that's good for all of us. But it does limit the employer's ability to have all the information. So a little bit concerning for employers, I think, from a ability to know all of the facts. So Colorado's doing this. We also saw this coming in Rhode Island, came from a completely different direction. We're going to talk about some drug testing changes at the state level. This particular clean slate legislation came out of marijuana legalization legislation in Rhode Island. So, and it says that past criminal and civil cannabis possession, some possession convictions will be automatically expunged. That's a 2024 timeframe that they think they'll have that done and in place. Those that want to have an expungement happening sooner can go ahead and go through that traditional filing of a petition process, and the court will waive fees or costs for that. But the automated part of that is set for 2024. Speaking of drug testing laws, I should have changed the order here a little bit. Actually, I will just go ahead. Rhode Island, let me just mention that, has legalized recreational marijuana. So that was signed by the governor May 25th, 2022. So we're seeing an immediate effect there. Adults over age 21 can possess and grow their own for individual use. Now that this law is in effect, as I mentioned, some of the marijuana possession charges are to be automatically expunged. Interestingly, municipalities within Rhode Island can opt out of the adult use industry unless they already have medical marijuana production or facilities in that municipality. And adult use sales can begin here in December of this year. So what does it mean for an employer? Not good news. I think actually employers' ability to take an adverse action on the result of an applicant or an employee's positive test is significantly limited unless there's evidence of current impairment at the time of the test. Evidence of current impairment is tough to get through a drug test. So you're looking for actual behaviors as opposed to being able to rely on that drug test result for marijuana positive. Employers, again, are still permitted to implement drug use policies and prohibit employees from being under the influence in the workplace. But again, testing for that's going to be tough. So it probably represents a lot more training, more documentation for the employer on recognizing behaviors, documenting behaviors, and making decisions based on some other factor other than a positive marijuana test. There is exceptions for safety sensitive positions, federal contractors, employee groups that are part of a collective bargaining agreement that have negotiated for that exception. So Rhode Island here joining a group of a couple of states now that are making it really difficult for employers, at least pre-employment, to test for medical marijuana, and then in this case to even post-accident will be tough for employers. Oh, I need to go back before I go to California, District of Columbia. So we did see the DC Council pass legislation also prohibiting private employers from terminating, penalizing, declining to hire workers who test positive for marijuana. That was signed by the mayor July of 2022. There is a 60-day congressional review period before that goes into effect, but coming up here, employers, private employers even, won't be able to fire workers or refuse to hire candidates that test positive for marijuana. Again, almost the same list of exceptions: safety sensitive, police, security guards, medical professionals, federal workers. Employers, again, can still take disciplinary action for actual drug use or impairment while on the job, but they're going to, again, need to be looking for evidence of that other than a positive marijuana test. So, and then some news outside the realm of marijuana drug testing, which we don't talk a lot about, but out of California, really interesting case. This was Johnson versus Winco Food Holdings. In that case, a class of applicants that actually did receive background screening offers and were hired by the company alleged that they should have been paid for their time as an employee, for their time of doing that pre-employment drug test. In this case, the employer's policy said the offer was contingent upon a successful background and drug test. The employer paid for the test, but didn't compensate for travel or time required to undergo the test. The court district ruled for the employer. The Ninth Circuit, which is the news here today, the Ninth Circuit upheld that decision for employers. They said class members were not employees at the time they underwent drug testing, therefore were not entitled to compensation. There was no case law on this point in California, if you can believe that. Usually, by the way, they would kick it up to the Supreme Court. In this case, they just said, it's really pretty clear to us. They relied on the control test that says, well, an employer's, in this case, they prescribed the date and time and location of the test. The test was just part of the application process and didn't control the job performance. So good news for employers. A little bit narrow in that the ruling probably is almost certainly is limited to pre-employment drug testing, right? So post-accident reasonable suspicion, there is, probably there's likely to be an employment relationship there. So employers should be thinking about compensation for that time. But on the pre-employment side, at least in California, employers, you now have case law on your side. So that's good news for employers. Moving on to E-Verify, just a reminder. So last quarter, we saw an update from SSA, DHS on the I-9 form, and during COVID, they were allowing some expired forms to be accepted. Similarly, now in the last month in July, earlier in July, we had this notification from the USCIS that runs the E-Verify program that the Social Security Administration is ready to resume their E-Verify operations. So during COVID, they were providing really extended timeframes when an employee was going through that I-9 E-Verify process. If there was a tentative non-confirmation on the Social Security number or Social Security Administration side, they were providing longer timeframes for the employee to get that resolved with the Social Security Administration. So they are saying now, effective July 15th, TNCs will no longer be allowed these extended timeframes. They're going back to 8 federal working days. So be sure when you're providing that TNC notice to your employee, the notice provides a deadline on it, but it's worth telling them as well if they've gone through this process during COVID. The extended time frame has gone away. It's 8 federal working days. They did say time frames that were provided between March 2nd of 2020 and July 14th of 2022. Those extended time frames still apply, but they cut it off and said any new TNC July 15th and after is back to that 8 federal working days time frame. So for our clients and friends who are using the E-Verify system, important to be paying attention to that. I mentioned in the agenda, we have some just interesting case law in the last quarter. So we thought we would just bring it up. This first one is out of Wisconsin. So not terribly broad, but very interesting. So Wisconsin has had a long-standing interpretation of employment law in Wisconsin. It was coming from the Labor and Industry Review Commission. They applied the substantially related test on consideration of domestic violence convictions in employment decisions. And so for many, many years, Wisconsin employers had to exclude or potentially had to exclude domestic violence criminal convictions from their employment consideration because it was the LARC was of the opinion that there was not a substantial relationship between domestic violence criminal cases and the employment environment, like in a position. And so we did see with Cree versus Labor and Industry, a Wisconsin Supreme Court decision that just came down, and they found the other way. So employers in Wisconsin now can at least be considering domestic violence cases in their background screening criminal records consideration process. Be careful, Wisconsin employers, right? You want to still be able to show that there is a substantial relationship between that conviction and the duties and responsibilities of the job. In this case, the candidate in particular, would have had access to manufacturing facility, really sort of unfettered access to other employees. They would have been working on their own. They would have been traveling on behalf of the company. So they came up with a new rule for employers to consider. There's 2 factors. One says the employer needs to consider the specific circumstances in the workplace that could lead to recidivism. So for instance, is there an opportunity in this job and the duties and responsibilities of this job to isolate a victim? Is there, like a lack of cameras or a lack of supervisory oversight, or do people work independently in isolated areas? And then the second factor of the rule was the existence of character traits that would indicate a willingness to repeat the offense. And the quote from the holding says, crimes of domestic violence, like other crimes, indicate a character trait of willingness to use violence against others, and that circumstances that threaten a perpetrator's power and authority could trigger a violent response. So a really interesting rule coming out of Wisconsin. I've talked to a number of Wisconsin employers over the years, and it was a bit of a head scratcher, I think, for some of us. trying to figure out how or why to exclude domestic violence criminal records from a policy. So I think this is positive news for employers in Wisconsin. If you've got a policy that currently excludes it, this might be a good time to be reconsidering that, looking at this case and see if it's applicable. If there's some applicability to the duties and responsibilities of your position. So interesting news in Wisconsin. On the national level, we did see some interesting FCRA litigation. So again, a new rule coming out of the 8th Circuit, which is really interesting. So limited applicability, right? Now we're not all subject to 8th Circuit rules. But what they did say was that, so let me give a little bit of background. In the Shoemaker case, so it was Shoemaker versus SD Data Centers Incorporated. This was a case where the individual had admitted to an arrest, not a conviction. During the background check, serious felony record was identified, reported to the employer. The employer determined that that person made them ineligible for the position, and they withdrew the offer of employment. Shoemaker brought a case against the employer. I don't have my notes in front of me, but I think it was actually they tried to create a class, and the concern was that there was no pre-adverse action notice. And instead of, so it was a little surprising because the 8th Circuit didn't find an FCRA violation. Instead, they said they declined the request to create an additional right under the FCRA, that is the right to explain to a prospective employer negative but accurate information in a consumer report prior to the employer taking an adverse action. So a little bit surprising, actually. I think we need to just be a little careful in narrowly interpreting and applying this. This is a case where the facts, I think, were very important to the outcome. I'm not sure how broadly this rule would be applied. It happened in this case that the criminal record the employer made the decision about was accurate, right? There was no mistake. The fact that there was no pre-adverse action didn't create harm for that candidate because it was true. And so the court was just saying here, I think, hey, employers, you still need to follow an adverse action process. But in this case, because the report was accurate, we don't want to create an additional right for a candidate to be, or for an employer to have to consider an explanation or consider some other information or mitigating circumstances. They just said under FCRA, at least, the employee doesn't get an additional right to explain an otherwise accurate report. So again, this decision really hinged on the fact that the report was accurate, and it also didn't take into consideration because it wasn't one of the pleadings. There was no pleadings about potential discrimination or the requirement to do an individualized assessment as EEOC guidance might require an employer to be doing. So employers take this with a grain of salt. It's a positive outcome for employers, but I think we also want to be making sure, employers, that you're thinking about FCRA obligations, even technical requirements to make disclosures, get authorizations, follow that multi-step adverse action process, which includes providing a copy of the consumer report, letting the candidate know before you actually take an adverse action that you're considering taking that adverse action, giving them information about their rights. In some states, you now also have to provide the candidate with specific information about what on the report is driving you to consider taking that adverse action, getting all that information out to the candidate, providing them with a reasonable amount of time to notify the employer of a dispute if there is something inaccurate or incomplete in the report, and then finally following up with that final notice that the final decision is final, if there's no individualized assessment, if there's no reinvestigation or dispute. So I'm not sure another circuit would have come out the same way. So again, just interpret this one narrowly, take it as a win for employers, and keep doing what you need to do to make sure you're meeting all those statutory obligations under FCRA and any state law that applies. We don't talk about the CFPB's interpretive rules very often, but we have had 3 on the topic of the Fair Credit Reporting Act in the last few months, so I wanted to just bring them up. The first one that we saw, or the I think maybe most interesting one that we saw, was related to preemption under the Fair Credit Reporting Act. So the FCRA does have language about preempting state statute. And we've all sort of been trucking along with the assumption that most state consumer laws are likely to be preempted. We know that's not true in all cases, but the CFPB in June here sort of reiterated that, hey, states, you still have broad authority to protect people due to credit reporting issues or consumer reporting issues by enacting consumer reporting legislation. It said state laws aren't preempted unless they conflict with FCRA or fall within one of the narrow preemption. And for instance, states could be legislating things like limiting medical debt or when medical debt could be reported, or states could be legislating, sort of the initial disclosures that need to be made in, for instance, a consumer or credit report that aren't already limited under what can be included in the under the Fair Credit Reporting Act. So an interesting take from the CFPB, an interpretive rule. They said that this interpretive rule was in a response to a New Jersey Attorney General notifying the CFPB of pending litigation, where one of the allegations in that litigation was that FCRA preempted the New Jersey Consumer Protection Statute. And so it was sort of a CFPB, I think, was preemptively creating rules regarding preemption, if we can use that word one more time. We also saw the CFPB earlier in the quarter in May actually reiterate in another interpretive rule that states have the authority to pursue law-breaking companies and individuals under the Consumer Financial Protection Act. So sort of, I think, a response to maybe some of the failure of at the federal level of legislators not passing federal legislation related to consumer protections. The CFPB seems to be trying to reach out to the states to encourage them to legislate or bring actions under either FCRA or CFPB. So interesting. I mean, I guess federal agencies do what they can, right? They create rules or where they can, or where they're seeing maybe some lack of legislation happening at the federal level. Speaking of that, they also published an advisory opinion about the FCRA's permissible purpose requirement, and they really connected that to a privacy right. How did they get there? It's not terribly straightforward, so we'll just talk it through quick. But they said end users, so that's you, employers, must certify to consumer reporting agencies like Orange Tree, and CRAs and end users have to have a bona fide reason to provide consumer reports. So in most of our cases, that's an employment purpose, right? There's some other permissible purposes where we're commonly doing background screening, but most of the time it's for that employment permissible purpose. They said that bona fide reason has to be one of those permissible purposes. And it said, consumer reporting agencies, therefore, you can't provide information to an end user unless there's reason to believe that the information in that report actually pertains to the consumer about whom you have that permissible purpose. And so what they were actually trying to get to were CRAs providing and end users relying on consumer reports where records are reported, maybe criminal records, maybe other negative information based on just a name match or based on a possible match. And so if you're working with a background screening company and you're regularly seeing notes on your report or disclaimers that say, this is a name match only, we don't know if it is actually your applicant, be really wary of that because the CFPB is saying, hey, that doesn't meet a permissible purpose requirement, and it's also a privacy violation for the other consumers about whom you might be reporting a record. And so, again, I think we're just seeing CFPB try to put employers and consumer reporting agencies and users of reports on notice of sort of, hey, if we can't get privacy legislation in some other way, we do still have the FCRA. And so here's how you can interpret the FCRA in a way that provides some privacy protections. Really, it just feels like an evolution a little bit to me. So we're talking about it, which is interestingly enough, we're also possibly seeing some action at the federal legislation level for a comprehensive data privacy statute. So we saw a bill called the American Data Privacy and Protection Act introduced in June of this year. It's really a comprehensive national data privacy and security framework. So what we have seen up to now is states are enacting individual state privacy statutes, definitely creating a patchwork, each a little bit different, each requiring something slightly different. And so this is an effort, I think, to create a national standard. The idea would be, as currently drafted, it would preempt state privacy laws with some exceptions. It seems like there's some provisions in the California law that wouldn't be preempted, but for the most part would be preempted. Would still have a carve out for information being collected under the FCRA or Graham-Leach-Bliley. It would cover entities that collect, process, or transfer covered data. So that seems in this economy like a whole lot of private companies, public entities, and it would cover data or information that's linked or reasonably linked to an individual or a device that's linkable to an individual with some carve-outs. It defines sensitive information, a little bit different from sort of the notice and consent regime. So at the state level, you're seeing notice and consent processes, GDPR, if you follow European Union data privacy, that is more about getting consent, providing notice, obligations for onward transfer. It seems like they're taking a different approach. It's more of a duty of loyalty provision. So that would be things more like, hey, data controller, you can only use the data for the purpose which it was collected, right? So maybe limiting some sale or other unrelated use. So an interesting approach there. We don't know if this is going to pass, right? Any federal legislation, I think, is not likely, frankly. But we're watching it closely. It does have some bipartisan support. It does feel like it's a little more cohesive. It's coming together in a way that past legislation that's been introduced in years past has not. So we'll keep a close eye on this one. I think as drafted, the bill had like a 4-year effective date. So it would give entities some time to implement policies and procedures and controls. But it does seem like it's pretty comprehensive and sweeping. So news there, and we just got to wait and see what happens with that legislation. And speaking of, right, we just talked about the fact that we've got a patchwork of states that are implementing or enacting data privacy legislation. Connecticut was this most recent one. They passed that in May. It's got a 2023 effective date, July 2023. So joining a handful of other states that have already enacting legislation, as we'll go through the bullet points here, it'll start to sound familiar, right? Sets responsibilities and privacy protection standards for data controllers, requires controllers to conduct data protection assessments to implement data protection controls. It does allow the state attorney general to bring an action to enforce, and it deems violations to be a violation of the existing Connecticut Unfair Trade Practices Act. So a little bit of teeth behind it. In general, it does carve out information that's already protected under other laws like HIPAA and FERPA, FCRA. It specifically excludes employee and job applicant data. So that's, I think, if not good news, at least a relief for employers in Connecticut. So, so I think it'll be interesting to see whether we have federal legislation to sort of make things let's say easier for employers, at least, if not easier, at least there's a single standard probably that employers would have to adhere to under a federal law, rather than trying to comply with a handful or two states enacting their own legislation. Okay.
That was it for Q&A.
Okay.
I guess you answered all the questions up front. Did you share your notes ahead of time?
No. Well, thank you, everyone. Our contact information is on the screen. If you have questions, feel free to reach out to us. And
That's